President Muhammadu Buhari has told a federal high court in Abuja that he believes that Section 84, sub 12 of the Electoral Act disenfranchises and discriminates against Nigerians in public service or public office holders who are political appointees. He says it prevents them from engaging in the electoral process in exercise of their inalienable rights in a participatory democracy. The president stated this in a reply to a suit filed against him and 12 others by the People's Democratic Party. He also states that he did not order the National Assembly to remove the contentious Section 84, subsection 12 from the amended Electoral Act 2022. The president said he only expressed reservations and concerns in respect of some provisions of the Act. All right, joining us now for more on this is lawyer and senior advocate of Nigeria, Kunle Adegoke, and ARISE Analyst Mahmud Jega joining us right here in the studio. Thank you both gentlemen for joining us. Let me start with you, senior advocate of Nigeria, Kunle Adegoke. Well, some two, at least, APC ministers who recently declared their intention to run for president. They are saying that the Constitution grants them the right to contest because it only says you should resign 30 days to the election. Do you think that this, how do you think really that this APC guidelines will play out vis-a-vis the provisions of the Electoral Act 84, subsection 12 that has been contentious for a while now?
The fear that it is possible for the court to uphold the constitutionality of Section 84(12).
Having issues there with connection freezing there, but okay, let's bring it back to Madam Mahmud Jega, right here in the studio.
Do you think that the electoral law, this controversial Section 84, subsection 12, is discriminatory? And looking at the APC guideline in particular, it doesn't tell the appointer to resign, but the appointee should resign. Do you think it's discriminatory?
Well, whether it's discriminatory or not, number one, it is a law passed by the National Assembly, so only a court of law can quash it. Now, one federal high court has already quashed it, but the National Assembly has appealed. Now, I'm not a lawyer, but the way I see it, whether the section is quashed or not, if you are a party member, the guidelines issued by the party for participation in the primaries are also valid, because even if there was no that provision in the Electoral Act and the party says you cannot contest in our primaries unless you resign from an appointed office, you have to do that, otherwise the party will disqualify you. And I don't think you can run back to the Constitution and say because the Constitution says civil servants and all that. This is not the first time it is happening. In the Second Republic, the same thing happened. The ruling National Party of Nigeria issued guidelines and said any minister who wanted to contest for governor, not even for president, that time nobody wanted to contest against the president, but whoever wanted to contest for governor or senator had to resign. That was the party guideline, and there was no Electoral Act provision like we have now. And several ministers resigned and went to pursue their gubernatorial ambitions. So the party guidelines also have effect irrespective of the Electoral Act provisions.
So what you're saying in effect is that there is a hidden danger if this appointees, go ahead to the primaries without resigning.
Well,
should it really be a question of morals or a question of law?
It's, number one, the party will disqualify them because these are the party guidelines. If they want to contest the party guidelines in court, you can imagine that is another long process. But the party is being careful, because if it does not have this guideline now, consistent with that section of the Electoral Act 84 subsection 12. What about if at the end of the legal process the courts uphold the validity of that section and possibly, let's say, one of the ministers who is now contesting for president wins the primaries, and then after that the court says the section is valid and he didn't resign before he contested? That means the party may end up without a candidate.
Okay, here we have back Kunle Adegoke, Senior Advocate of Nigeria. We lost contact with you earlier. So sorry about that. Apologies. But let me just keep it as briefly as I can. The question I asked Malam Mahmud Jega here, I mean, you're a lawyer. You would have a better grasp of the legal, fireworks that could play out eventually. Are there hidden dangers in appointees going to the primaries without resigning? And is the APC within the law to actually ask, aspirants to resign, in spite of the fact that the Constitution states clearly that they have 30 days to resign if they're to contest?
Something first. The Constitution does not require political appointees to resign before they can stand for an election. It is the novel provision of the Electoral Act, Section 84.12, that is providing that political appointees must resign before they can be featured in an election, before they can participate in the primaries of a political party. The Constitution requires only persons employed in the civil service of the Federation, in the civil or public service of the Federation, to resign 30 days before the election. Now, that provision has been interpreted not to include persons who are political appointees. Political appointees are not the same with persons employed in the public service of the Federation. That is why Chapter 6 of the Constitution makes persons employed in the public service of the Federation to be part of the executives. And since you cannot hold two executive positions together at the same time, by virtue of Section 138 and 183 of the Constitution. So anybody who is employed in the public service of the Federation or state cannot participate in an election without resigning 30 days before the election. However, political appointees are not persons employed in the public service of the Federation. That is why the Constitution does not say anything about political appointees. It is not a requirement of the Constitution that a person who is a political appointee should resign before an election. It is the Electoral Act that is now making this provision. And that provision, to the best of my knowledge, is unconstitutional. The reason is this. The requirements for the Constitution, for qualification to participate in an election, as stipulated by the Constitution, can be seen from the provisions of Section 177 of the Constitution and 182 relating to disqualification from contesting an election under the Constitution with regards to governorship election, for instance. And this cuts across all offices recognized by the Constitution. To that extent, anybody who is a citizen of Nigeria by birth, who has been sponsored by is a member of a political party and has been sponsored by that political party, is of a certain age equivalent to what is required for contesting a particular office, and has up to school certificates or its equivalent, that person is qualified to contest an election. However, with respect to disqualification, it is not provided that a political appointee shall resign. Now, when you look at this, insofar as the Constitution has summarized what is required for you to be qualified to contest an election, and has stated the grounds upon which you can be disqualified, no law can add anything to it or can remove from it. The Supreme Court is very categorical on this in INEC and Musa, that any law that purports to add to the Constitution is a nullity. To
Senior advocates, let me stay with you and very quickly, because this is beginning to look like a battle of the Constitution versus the electoral law. On March 17th, a federal high court in Ibadan dismissed a suit seeking the deletion of Section 84 subsection 12. A day after, another federal high court in Umuahia, Abia State, struck down the same section 84 subsection 12. And currently we have another case here in Abuja on this same controversial law or section of the electoral law. You understand the law. As it stands with all these cases I've cited, what is the position of the law when it comes to the controversial section 84 subsection 12 in Nigeria?
Now, the position of the law is that that particular provision, as it stands today, is unconstitutional. It will be contested up to the Supreme Court. I know the fear of APC. I am a member and a leader of APC too in my own capacity. And I realize that my party is trying to play safe so that in case it happens that provision of the Electoral Act 8412 is upheld by the Supreme Court, that the party will not lose out in the process. However, it is also the case that any minister or commissioner or any political appointee who is disqualified on the ground of Section 8412 too will challenge it up to the Supreme Court. And the implication is that any candidate featured by the party on the basis of Section 8412 may not be able to retain that particular seat because somebody who is otherwise entitled to contest that particular election has been disentitled by the political party to which he belongs. So that is why the situation is actually dicey. There is no doubt about it. But political parties are required to seek correct legal opinion on this. I think it is better for political parties to assemble sound legal minds to interpret this. People who will give honest and correct opinion. And I'm quite convinced 100% to the effect that if this matter is fought up to the Supreme Court, it will be upheld that Section 8412 is unconstitutional. No law made by the National Assembly or State House of Assembly can add to what the Constitution has stipulated. If somebody is a person employed in the public service of the Federation, that person is required by virtue of Section 182 of the Constitution, for instance, to resign 30 days before that particular election. Section 8412, that is now saying that anybody who is a political appointee must resign before he can participate in the nomination process of a political party, has added more to the qualification requirements of the Constitution. There is a plethora of authorities from the Court of Appeal. Very quickly,
because we have to wrap this up, and we still have Mahmud Jega here with us. You sound very confident that the Supreme Court will quash this. Is that where the confidence of the ministers are coming from? Some are even declaring openly that they would not resign. Is that where they are deriving the confidence not to resign from, even though the party has given them ultimatum, and from the calendar and from the dates issued, they have just about 72 hours to go?
Yes, I believe that is where their confidence is coming from. They have consulted best legal minds in Nigeria, and I believe that they have been assured that this is the position of the Constitution, which is supported by at least two Supreme Court authorities. If you look at Shinkafi and Yari, the case arising from Zamfara in the last 2015 election, and also Alassane and Ishaku, which came from Taraba State, you see that the Supreme Court categorically stated that no law can add to the qualification requirements as stated in the Constitution. And where the Supreme Court were to go back on this position of the law as stipulated, and the Constitution has not changed. The Constitution from 1999 up till now on this particular issue has not changed. So it has become concretized. So I believe that is where their confidence is coming from, and it is quite justified.
All right, very quickly. I wonder what you have to say about that. And barely 3 days to go. Do you think the APC even has the courage, the political will to go ahead and do the needful, ensure that this political appointees actually step down if they're still going to run? Because
there are, political parties are like social clubs in some sense. They can introduce rules, not necessarily the ones that are in the law. You go to an army officer's mess and they say that you cannot enter if you are wearing bathroom slippers. You cannot cite the Constitution and say it allows you to walk into. Now, even if the section of the Electoral Act is voided, political parties have certain rules that, for example, the parties will say if you have not been a member of the political party for the last 2 years, unless if they grant you a waiver, you are not qualified to contest in their primaries.
We'll have to leave it there. Thank you so much, Malam Mahmud Jega, for joining us, and Kunle Adegoke, Senior Advocate of Nigeria, on the APC and, of course, the Electoral Act.